I'd like to first welcome Assistant Secretary Washburn to the hearing. Your testimony is important not only for the groups who seek to confirm a nation-to-nation relationship with the United States through the administrative process, but also for existing federally recognized Indian tribes, their governments, and state and local communities who may be impacted by federal recognition of the new Indian tribes. And thank you for being here today. In this subcommittee's hearings on federal recognition process in the 112th Congress, we heard testimony from 3 groups who are seeking federal recognition. These groups are either actively seeking acknowledgement through the administrative process or fail to meet the acknowledgement criteria and are therefore seeking recognition through legislative or judicial decree, or both of them. These groups testified to their experiences as the Office of Federal Recognition petitioners, and the message was quite clear: the system is broken. They testified to the high cost to gather information and present a successful petition, the length of time petitioners must wait to learn their status, and the lack of transparency with which the OFA received, reviewed, and advanced their petitions. The witnesses also testified that the recognition criteria do not take into account or are even hostile to their unique historical circumstances. They were very clearly frustrated, tired, and dismayed by their experiences. As a member from Hawaii, I've led legislative efforts in the House to achieve federal recognition for Native Hawaiians. I understand how difficult the process of federal recognition is and recognize that the regulatory barriers to achieving federal status for petitioning groups are many. That is why I support meaningful reform through the OFA process that takes into account suggestions from all interested parties, the general public, federally recognized Indian tribes, and petitioning groups, for reforms to administrative acknowledgement that improve OFA's transparency, timeliness, efficiency, and flexibility. The last revisions to the regulatory process found at 25 CFR Part 83 were made in 1994. It is well past time to revisit the regulations and identify changes that can be made to expedite the process, make it less financially burdensome and more transparent for petitioning groups, some of whom have been waiting decades for a decision from OFA. I look forward to hearing the administration's testimony on when, not whether, reform can be made in the near term. Thank you, Mr. Chairman. I yield back. Secretary Washburn, you laid out the timetable, which I'm interested in. You said that sometime during the summer you anticipate rolling out the draft to us and then engaging in rulemaking process after that. When do you anticipate starting the rulemaking process?
You know, Madam Ranking Member, that will depend on kind of the comments that we get back. You know, do we come up with if we have a proposal at the front end that is acceptable to people, it could happen sooner. If we really have to go back to you know, and really rethink things, it will take a little bit longer. We kind of came into this with the idea that it probably takes 2 years if everything goes well to accomplish this sort of thing because of all the steps that need to happen in the process. And we would love to have it done faster than that, but we also want to be careful to get it right because we have talked about doing this for more than a decade, and it's time to get it done. We want to get it done right this time, and so we hope you'll be patient with us, but we certainly want to move as expeditiously as possible.
Mr. Secretary, there's also another schedule, which is that you know, it's a 4-year term for the president, so more than likely it's a 4-year term for yourself. So given that fact, I mean, you might want to take more time, and we might want to take more time, but it would be, I think, a great disservice to those who've been waiting for these changes since probably around 1994 to then tell them it may take 4 years or it may take 3 years, and then we're not able to avail themselves of the process under those who, in essence, are creating it. So is 2 years the best estimate you have in a perfect world situation?
I think that's fair to say. Let me tell you that we came in talking about this and ready to work on it from the moment we started. Mr. Roberts started about a month before I did and had an interest in this area. I heard a lot about it during my confirmation process and from former assistant secretaries, and several of them said, I wish that I'd gotten that done. And we knew that to get it done, we needed to focus on it early. And so we have you know, started from day one working on this issue, and we do hope that 2 years we can get it done in 2 years so we can move on to other important matters.
And how many petitions are presently pending, and what happens to them while you're engaging in this potential rulemaking process, which may take place as early as summer, but may take 2 years? What's going to happen to them?
Well, we have talked about what to do with those processes. Certainly, we hope to make improvements in the process. And so one of the issues is, do we force people to go through a process that's currently being renovated? And I've lived in a house while it was being renovated, and that was not a pleasant experience. And so there may be people, groups that would like to sort of stay there, petition, while we make improvements to the process. We don't want to force people to do that, but we have talked about giving them the option to, place a pause on their petition so that they can see if the criteria could change, and they may prefer the criteria as that come out in the future if we make changes to the criteria. And so we want to leave the flexibility in the process so that they may do that if they wish to do so. I should have the number of pending petitions here before me. I believe we have 9 on active status. We have 4 on ready status, and 265 groups that have submitted partial petitions, such as a letter of intent, but which have not fully completed their applications.
Now, Mr. Secretary, one of the issues that we've faced in this committee is the Carcieri decision. And, of course, the magical year there is 1934. And given the fact that we still do not have the Carcieri fix, so that's something I know that the chairman and I would like to see done, what are the chances that once your new process comes in that you're going to actually create 2 classes of Indian tribes? Pre-Carcieri, the Carcieri ones who met the deadlines and the ones who are now post-Carcieri.
Well, Madam Ranking Member, that's a real risk. That's a real problem, frankly. Until Congress can fix that Carcieri decision, that is what happens. We frankly currently have 2 classes of tribes, and we would like to treat all tribes the same, and we've asked Congress for a clean Carcieri fix. But until we get that, we are going to have some tribes that are recognized for whom we can take land into trust, and other tribes that are recognized for whom we cannot take land into trust. There's a real risk that a lot of the tribes that we recognize going forward will not have the power to take land into trust, since they, likely were not under our jurisdiction in 1934.
Thank you, Mr. Chairman. I yield back. Following up of what the chairman basically was talking about, do you see any way that you can fix the Carcieri situation just by regulation?
Madam Ranking Member, no. We will never be able to address the Carcieri situation by regulation. We certainly, it will endeavor not to apply that case any broader than it deserves to be applied, or any narrower than it deserves to be applied, but we don't anticipate that we can solve it entirely by regulation.
Following up on what the chairman was speaking to, which is that how many tribes fall in this sort of like this area where they may have been recognized post 1934, and therefore based on Carcieri does not have the rights, of course, to Indian country and having lands taken into trust by yourself. Now, do you have any idea as to how many tribes are in that category?
No, we don't. We've done a case-by-case analysis each time we've gotten a land into trust application. We have to do it sort of for our work. We haven't done a broader survey to figure out sort of generally who falls into which category. And frankly, it's extremely time-consuming. The Carcieri case has put an enormous burden on the staff at Department of Interior because we now have to conduct a fairly extensive historical legal analysis anytime we wish to try to take land into trust for a tribe. So we haven't sort of done it generally as regard to 566 different tribes or, the 300 plus that are outside of Alaska. We've just kind of been going about our business, and it's added a huge burden to our business that we go through already.
Well, let me ask it this way. Of the ones that have taken your time and it's been time-consuming and you've done the analysis, how many have you come up with the decision that you could not take their lands into trust?
Madam Ranking Member, I don't have that figure at hand. I will tell you that it hasn't been very many. We haven't had the decision really that long. And, tribes didn't spring for the most part from thin air. That, most tribes that we work with regularly were around in 1934. That's just the facts for most of the tribes. And so I wouldn't anticipate that it would be very, very many. But it's an issue that we, have to carefully consider anytime we take land into trust.
You said something very interesting, because we're trying to figure out how to best proceed with, as a result of the Carcieri decision. You said most tribes have been around since or before 1934. Now, that's a different statement to me than a tribe that is federally recognized. So are you saying that as the secretary in charge, that if a tribe was in existence prior to 1934, was around before 1934, that somehow that would then satisfy the requirement of being federally recognized? Because I think we're being trumped on this phrase, federally recognized.
Madam Ranking Member, you're a good lawyer. I would tell you that, and I should have spoken with a little bit more precision, frankly. Even under our Part 83 process, we are only recognizing the existence of a group that has proven that has been around, sort of since time immemorial, basically. So it's, every tribe, in essence, was around in 1934. So the more narrow question that Carcieri poses is, were they under federal jurisdiction in 1934? And, given the trust responsibility, we think that most of them were under our jurisdiction or our responsibility in 1934. What the recognition process does is it finds those tribes that, while were a distinct group as of that time, were not sort of having specific interactions with the federal government regularly at that time. And that's the difference.
And so a tribe like you just described could arguably fulfill the Carcieri definition of being there since 1934, recognized not in a sense of being stamped or anything like that, but notwithstanding under your jurisdiction. And as long as you make the distinction that the tribe is under your, somehow would be under your jurisdiction, that they would then satisfy Carcieri, because Part 83 really just determines whether the tribe can be recognized. Am I understanding you correctly?
I think that that's fair to say. But having said all of that, we really would like to see Congress act to address the decision, address the Carcieri decision.
Thank you. I yield back.
We intend to do that.